Thank you for joining us today. My name is Quinn. We have a special edition of IPWatchdog webinar series with some of our good friends from Germany. Renee will introduce them momentarily. There was a big event happen in the UPC recently relating to standard essential patents specifically. More generally, I think I would say it relates to just injunctions, which has impact for everyone, not just those in the SEP space. So we got a great conversation. We're going to hear about what's going on over at the UPC, this case in particular, and answer as many of your questions as we can get to. So Renee, I'm going to kick it over to you. Let's introduce our speakers, please.
Sounds good. So I'm going to introduce them from left to right. We have Dr. Tobias Wuttke. He's a partner and attorney at law with Bartoli Paggenberg and one of Germany's leading patent litigators. He brings extensive experience from hundreds of national and cross-border infringement and validity proceedings. Tobias advises global companies acting on a global level, innovative SMEs, and startups in the areas of telecommunications, medical technology, automotive, and life sciences with a strong focus on standard essential patents. Next, we have Arie Tol. He is a principal licensing counsel in Philips Intellectual Property and Standards, bringing nearly 30 years of experience across a broad range of intellectual property matters. In recent years, his work has focused primarily on patent licensing, particularly of standard essential patents. Arie is a Dutch and European patent attorney and registered UPC representative. And on the right, we have Dr. Tilman Müller. He is a partner and attorney at law with Bartoli Paggenberg. He specializes in patent litigation with deep expertise in infringement and nullity proceedings before national courts and the UPC. Tilman is particularly experienced with patent pools and standard essential patents in technologies like video, audio, telecommunications, and lighting. He's represented major players including Access Advance, via licensing, and Philips in complex cross-border disputes, and also advises on licensing programs and international standardization. And last but not least, we have Quinn. He's a patent attorney and a leading commenter on patent law and innovation policy. He founded IPWatchdog in 1999 and since has twice been named one of the top 50 most influential people in IP. He's regarded as an expert on software patentability and U.S. patent procedure and has repeatedly been recognized as one of the top IP strategists in the world. Back to you, Gene.
Great. Thanks a lot, Renee. And once again, thank you all for being here with us today to have a conversation about really what is a monumentous development, I would say, at least if you're a patent owner. If you're not a patent owner, maybe if you're a target, if you're an infringer or alleged infringer, maybe you might be a little bit afraid now. But I'll let our experts over in Germany do most of the talking here. I have more questions than I have answers. But let's throw it to them, generally speaking, in the first instance, to get their lay of the land, their thoughts on what this means, big picture. And Tilman, I'll start with you because you were the main attorney in this case, if I have that right.
Well, I don't think somebody can be main attorney over Tobias. So we did this together, and of course as a team, also with others who can't be here today. But yes, it was an exciting ride over the last 2 years, and maybe to provide everybody a little bit of background. The UPC case we started in June 2023, right on the very first day of the UPC coming into place. That wasn't the beginning of the story. Rather, we had already started litigation against Belkin in front of the German national courts in 2021. And actually, quite shortly before the launch of the UPC in February, March 2023, we had these cases that we filed at the district court in Düsseldorf come to a hearing and then to a decision. We had parallel German nullity cases pending against the patents as usual, so to say. And must admit, that made this case also remarkable. The very patent we asserted then and that we won on now at the UPC was found non-infringed at the district court in Düsseldorf only in March. But Philips was convinced the decision was wrong and now proven right. So we decided to assert the patent once again at the UPC a couple of months later.
That's great. So before we dive into asking specific questions, let me get Tobias, your preliminary thoughts. What should the audience be thinking about today? Where do you want them to have their brain as we really dive into this conversation?
Yeah, I think the main lessons learned is the Court of Appeals has endorsed the first instance decision, kind of has also now enshrined an infringement test, and also has established the principle that we have de facto an automatic injunction system. That means not that there are exceptional scenarios where you can make a proportionality defense and kind of water down the injunction, but as a general rule, there will be an injunction.
Mm-hmm. Great. And Arie, your initial thoughts?
Yes, indeed. I think it's a very important touchstone of the Unified Patent Court that, of course, we were promised certain things. And I think with this now Court of Appeal decision, we see a lot of things actually being delivered. Tobias mentioned the fact that injunctions would be available from this court, and the Court of Appeal has confirmed that such is the case, not as an exception, but as a rule. So I think that's an very important point that is now established. They also managed to do it in a timely manner. They managed to do it in a timeline that we were promised up front. So also on that point, the tick mark is there. Quality is another thing. I think it's always difficult to be entirely objective when you've won a case. But I think in general, and also this case is a case at hand, we see good quality decisions coming out, also in line with expectations, because the judges that are appointed to this court were among the best in Europe, in the national courts. So I would say on many fronts, the Unified Patent Court seems to be delivering what it promised to deliver. I think that's and this decision is the first major proof point to that respect, because it's the first decision that made it right to the end on the merits.
Great, excellent. So let me just peel back the layers of the onion a little bit to punctuate a couple things and make sure we're all on the same page. So the initial decision at the trial level did not go in your favor. You appealed that. And the appeal then does go in your favor and does issue a final permanent injunction.
Well, small caveat. So the initial decision, first instance decision at the German National Court did not go in our favor. Then a couple of months later, 1st June, we filed a new action, first instance at the UPC. And in fact, that went in our favor. The decision came out September last year, 24. Belkin appealed this. We also appealed one aspect of the decision. Might come later to this. One prayer for relief we had filed was not granted. But essentially, the first instance decision was confirmed then on appeal by the Court of Appeal.
Okay. So, and is this the final appeal, or is the other side have an opportunity to appeal any further?
No, that's it.
So this is it. The case is now, which is why you can actually talk about it now. Okay. Just, I'm slow sometimes, but I can come up to speed pretty quick. So this is great. So now there was one aspect that I think, and if anyone has any questions, please send us your questions in the Q&A box here, and I'll get to as many questions as I can for the panelists here. But one question I would think that a lot of people would have in their minds is, so you had both a German patent and then you had a patent that you could use at the UPC. And so it gives you as the patent owner with the proper strategy, it sounds like maybe a couple opportunities, a couple bites at the apple, which I think a lot of people did not think was going to be the case with the UPC originally. But as it's developed, and Tobias, I see you're shaking your head. Maybe you can address this, because you and I have had this conversation before about the fact that you can have multiple bites at the apple as the way things have developed.
That's certainly true, but we also come to that applies to both sides. And now it only applies for the first 7 years of the lifetime of that court, when we have a transitional period for the existing European bundle patents. Yeah? Once this transitional period is over, the UPC has exclusive competence, and you can in the future then only go to the UPC. But currently, you can go both to the national courts or the UPC. And here's the thing. You can a little bit play with these options as a patentee. For example, you carve out certain territories from your UPC action, and the territories you have carved out, you go national. You can also decide to assert your patent against certain defendants before the national court and against other defendants before the UPC. So there is really a lot of flexibilities, but it goes both ways. Also, the defendant can then challenge the patent both before the UPC and the national courts if we are talking about a European bundle patent, this traditional patent. If we are talking about a unitary patent, this new right, which is available for 18 UPC countries, then it means this unitary patent only goes to the UPC and can only be challenged before the UPC, plus as long as the EPO still has this opposition window open also before the EPO.
I think, Tobias, that was one very important point you made, that by choosing your defendants, you can also basically assert the same patent twice against the same group of companies. And that's a bit what we did here, because we had sued the German GmbH in front of the German court for infringement of this patent in Germany. And we couldn't bring this case with the very same scope at the UPC. That would not have been possible.
It would be lis pendens or res judicata. If
yeah,
the
okay,
German
so it's not
was.
exactly a do-over, but
No,
it is,
exactly.
you do have two paths that you can pursue.
Right, and that's why we involved the directors of this company into the proceedings to try to get a hook on the same company, so kind of via the liability of their directors. But it's probably something we would have not done otherwise.
We have another question here about, Tobias, can you clarify that 7-year rule? I know what you meant because we've had these conversations before, but where does 7 come from, and what is that intended to be all about?
That's a political compromise. When the UPC started, the member states that founded the UPC via the Agreement on a Unified Patent Court said, we give this new court all existing European patents. That means over 4 million patents go to this new court, where no one knows how it will handle these 4 million assets. Yeah, I mean, wow. But then they said, okay, in the initial phase of 7 years for this existing body of traditional European patents, you can choose as a patentee. You have flexibility. Either you bring it before this new court, if you trust the new court, or you bring it before the national courts. And I think what is surprising to the whole industry, after now a bit more of 2 years into this new system, and that's also at least the experience with my clients, it's no longer the question, why should we use this new court? The question is, why shall we not use this new court? The new court, the UPC, became the default setting for this existing body of 4 million patents. And in so far, you could say this transitional period was overly shy from the founding fathers of the UPC, but they were simply afraid that there was not enough trust within the community of patent holders to bring the cases to the new court.
Well, this case probably goes a long way to build up trust, I would think, for anybody who is a patent owner. And we have a question here, and I think, well, I'm going to take a little issue with part of the question here, but let me just get the question out. It says that a de facto or automatic injunction system seems to provide patent owners the ability to hold up. Do you believe there's a possibility that the European Commission will reinstate their proposed SEP regulation in response to this ruling? Now, whenever the issue of patent owners holding up comes up, I always just like to point out that that's not true. That doesn't happen. There's no evidence that that's happened. That's been now thoroughly debunked by all the literature over more than the last decade. Patent owners have rights. They only get paid if they're licensing others to do them, particularly in the SEP space, because those people who are innovating are innovators, and they don't, by and large, have their own products. Their product is the innovation. It is the patents. So there's zero evidence of patent owner holdup. There is a tremendous amount of evidence of infringer holdout. And that's why in the U.S., things have really gotten off the rails, and why a lot of U.S. Patent owners, and really patent owners around the world, are really interested in looking at what's going on in the UPC, because it has seemed up until now, and now I think we have conclusive proof of this, that they were going to be more patent owner friendly than the courts in the U.S. I don't think that the UPC is giving patent owners a rubber stamp, but the fact that they get a fair shake is, I think, very different than what our experience is in the U.S. If you want to comment on that part of the question, feel free to, guys. But what do you think is likely going to be the response from the European Commission? Are they going to breathe life into that SEP proposal, do you think? Or is that over and done with?
That's a tough question. I think the whole initiative by the European Union has not disappeared. I think it's may disappeared from the top of the agenda, but it may come back. Whether the particular case and development now makes them rethink the whole thing, I'm not so sure that will happen. Basically, what had happened is not astonishing, not surprising, in the sense that it is a completely different outcome than one could predict from the outset of what this court could do. So, yeah, they have no reason to be surprised. So, yeah, that's all I can say about it. It's a bit in the mist how the EU now will proceed with this matter.
But I agree with you, Arie. I think this would not be a case that raises eyebrows with the EU Commission when they had their intention of the regulation. And one must say, putting this out, getting all the negative feedback, and then withdrawing it was certainly not a big win. And I think they will be careful what they put out next. But in any case, I don't think this type of case that we are looking here, this type of decision, was what made them think about this regulation in the first place. They had other larger impact or different scenarios in mind, I think, where you shut down whole networks, whole industries or something like that. So I agree with you. This, I don't think, will have a larger impact. And maybe, I know in the US, injunctions are fairly uncommon. And I understand that the concept of an automatic injunction is strange, but it works. We have been living with it for quite a while in Germany, and now the UPC follows more or less the same concept. So I think it's a viable way forward, and you might have some criticism about it, but it's not the end of justice or collapse of the system or something like that.
Yeah, just to add.
Go ahead, Tobias.
But like Tilman said, if the right case comes from a defendant's perspective, we will, of course, get a discussion about eBay versus Merck, proportionality considerations, and maybe it will also be referred to the Court of Justice of the European Union. We have an enforcement directive placing an emphasis on proportionality. But again, not for every case, it must be the right case. And then the discussion, depending on how the system develops, may get up speed again. What I think is important to emphasize, the balance in the system is certainly the invalidity attacks that are available to defendants. Yeah, you can challenge the patent with a counterclaim for invalidity, like in the US. In addition thereto, a different group company can bring a central invalidity attack to the UPC. If we have these traditional bundle patents, you can also bring a national nullity action. So you can go to the European Patent Office for opposition. So there are many bites at the invalidity apple too, and the patentee has only a limited amount of time to defend and to bring his what we call auxiliary request, where he says, okay, the claims as granted are maybe invalid, but in the limited form they are valid. So there is a balance in the system.
Yeah. So it's not necessarily a panacea. It's not a cure-all elixir for patent owners where they have nothing to risk or nothing to lose. And defendants who are alleged infringers are just at the whims and fancy of the UPC. That's just not the reality. I think people in America get excited because it does feel like if you are a victorious patent owner, you will get an injunction, which to me makes all the sense in the world. Even in the US, even before eBay, we did not have an automatic injunction rule. What we had was a very strong presumption that an injunction ought to issue, which if you actually take a step back and think about it, makes all the sense in the world, because a patent is supposed to be an exclusive right. So if you prevail as a patent owner and prove that somebody is infringing, really all an injunction does is say, don't infringe the patent moving forward, which is what the patent is supposed to stand for from the very beginning anyway. So I find it difficult to accept arguments about, automatic injunctions are bad, even if they are automatic. Even if this turns out to be in the UPC, it is strictly automatic. You win, you get an injunction. What could possibly be wrong with that? You're infringing. You're not supposed to be infringing. Stop infringing. Engage in a arm's length negotiation with the people who have the rights. I'll give you an opportunity to comment on that rant if you want a little bit, or if you don't want to open that can of worms, we can move on.
Maybe just one brief comment. It's not an strictly automatic injunction. It is rather, as you described it prior, eBay Merck, there's a strong presumption. And you can see this in this decision here. One aspect that was debated a little bit in more depth was the recall and destruction of products. So if you get an injunction in our system, you also are ordered as the implemented patent infringer to withdraw all the products from the market and destroy them. That claim had been rejected in first instance, because the court stated we had not said why it was needed, basically. And the appeal court said, no, this is the standard relief. If the implementer has a substantial issue, if there is disproportionality, then the implementer should set this forth. And that's the same standard you apply to an injunction if this causes somehow irreparable harm, or it's really disproportionate. You would shut down the entire mobile phone network in Germany. That would be probably such a case. Then no injunction is issued. But the standard case, vast majority, I would say 99%, there's an injunction. It's a strong presumption, but not automatic.
Okay. So we have a question from Kent, who asks about SEP cases specifically in FRAND. Who, besides the patent holder, determines whether or not a FRAND-based value was used in making the damages demanded? So how I guess maybe a broader question, I think what Kent's trying to get at here is, walk us through how is this FRAND dance handled by the UPC? Because obviously the patent owner has an obligation to offer a FRAND, and who decides whether that offer by the patent owner was FRAND, and how does that all work?
Yeah, maybe I can comment on that. So the general concept of this FRAND dance is you start with an infringement notice from the patent owner. The implementer has to respond and express interest. Okay, I want to discuss. Then the patent owner is supposed to make a license offer, and the implementer in turn has to respond in due course and make a counteroffer, and also provide security for the royalties which are at stake. Now, the whole concept is much less focused on what specific royalty is FRAND, because the UPC, but also I would say European courts, aside from the UK, take the position this is a range and it's very difficult to pinpoint a specific royalty that is FRAND. So it's much more a view on how the parties behave, and are you negotiating constructively in a timely manner, good faith towards a license. That's basically the test. And if you, as an implementer, do not meet this test, you are very much at risk of getting issued an injunction. On the other side, if as a patent owner, SEP owner, you do not do this dance and you don't negotiate in good faith, then most likely you will not get an injunction and you'll be down to damage claims. The question, what is actually FRAND in substance, hardly ever comes up. You can make it part of a declaratory counterclaim as an implementer. You can counter sue for a declaration these specific royalties are FRAND or so. But normally it is really more a behavioral, a dancing exercise, rather than finding the right number.
All right, so we have a couple questions that are kicking around this geographic limitations, I guess you might say, of courts and the impacts of the rulings. And maybe I can walk through it in a series of questions. I guess the first question, just to get it out all on the table, is so if the court here in the UPC issues a ruling like they have, that applies across all of the UPC member countries, correct?
Yes and no. It only applies to those member states where you actually have the patent.
Okay.
So in our case, that was not the full set of 18. It was a subset of the 18.
Okay.
If you have the unitary patent, which wasn't available at the time for our invention, then it applies automatically to the 18.
So let's just hypothetically say that we're dealing with a situation, not yours, not this one, but the next one, where there is a unitary patent. It'll apply to all of the countries that are members of the UPC, but that doesn't include the UK, right?
That's correct.
Correct.
Okay. And that's of issue to people and of concern. Maybe is not the right word, but people want to have answered, I guess, some questions about, well, what does that all mean? Because the UK has become a pretty active jurisdiction for standard essential patents in particular. I mean, there's a handful of them right now. The UPC is a big player. The UK is a player. The US is a player to some extent, maybe a large extent for a variety of reasons we don't need to go into right now. And then I think China probably is another big player. And those jurisdictions don't always agree with one another. Actually, it's kind of happenstance when they do agree with one another, it seems. So how is that going to work? Do you see these major jurisdictions deferring to decisions of the UPC? Is the UPC going to have a leg up because they're going to be setting these FRAND decisions as applies to so many countries all at the same time that it's just not going to be feasible for another jurisdiction to come in and say, oh, but we're going to have a different outcome in our jurisdiction? Or how do you see that playing out longer term?
Oh, that's a big question.
What is your best guess?
I think, well, it starts with, I think, a court can only decide on a case if a case is brought to that court. Mm-hmm. That's where it starts. So then the question is, who would bring the case normally would be a patent owner. So where would a patent owner start his case, looking at the landscape of today? So he has the options. He can start a case in the US, go to the UK, go to the UPC, go national Germany, maybe China. So which one would you pick as a patent owner? Also, if you have the patents in all of these geographies, that's a prerequisite, obviously. But when you come to FRAND cases, these are typical global matters where the companies at stake have patents in all of these jurisdictions. So they have a choice. So where would you go? Then if we have to choose, if we come to the unfortunate situation that we have to litigate, it's not something that we do because we like it. It's something that we do because other things have been exhausted and have not led to a result. Then I think 4 factors are important. The first factor would be impact. So you will be looking for a case basically that changes the game, that you couldn't get to an amicable resolution of your case. So you need something to change. So you need something with sufficient impact. And we talked about the injunctions, the UPC, combined with the 18 states, a market of comparable size as the US market, maybe the Chinese market. With an automatic injunction, I think gives you the impact that is as big as you would have an injunction in the US, for example. You will be looking for quality. We talked a little bit about quality. I think the UPC is also well set to deliver high quality decisions because of the judges that are involved in it. And then also you would want to have a decision which is also reasonable as to cost. And also, I think in this respect, if I compare the UPC with the UK and the US, for example, it is a very attractive offering. And then finally, you want a decision which is timely. And I think also on that front, the UPC has a strong suit. It promised you a first instance decision in little over a year. That is very quick. Compared to other jurisdictions. So I think as to FRAND cases, I would predict that the most FRAND cases will be brought to the UPC by patent holders. Some may go to the UK because they provide sort of the service of having a global FRAND determination, which is very much still in midair whether the UPC will actually go as far as that. But then you have to have the size of case that justifies going to the UK court because you will pay a hefty price to litigate there. It might be even a factor of 10 compared to the UPC litigation cost. It's a very lengthy answer to your question. I hope
that was
helpful.
That's probably the best answer we could get. But, on some level, I wonder, and feel free to comment on this if you want, or you don't have to necessarily. I wonder to some extent whether it ultimately matters, right? Because if the patent owner is, and now I would think many, if not most, if not almost all patent owners in the SEP space are going to want to go to the UPC if they can. And if the UPC issues decisions, relatively quickly, which they do. I mean, this case from start to final decision, final non-appealable answer reached in just 2 years. I mean, that's light speed. And what I think we have seen, particularly in the SEP space, but not only there, but in the pharma space, and we call it for patent owners who have a really truly global portfolio. If you can get a win in a major jurisdiction, that has influence on every other jurisdiction in the world. Maybe not from the judges giving deference to that decision, but in the telecommunications industry, for example, you cannot afford to be prevented from selling in Brazil. I mean, it's the 4th largest telecommunications market in the world. So if you get an injunction in Brazil, for example, that influences everything else. The same, maybe even more so, for the UPC. I know the UPC is not coextensive with Europe or the EU, but it will be at some point. It's going to continue to grow. You're going to get more and more countries. And if you get a win in the UPC, these folks who are the now infringers based on the decision can't abandon those countries. And the way that in the SEP space, particularly, things get settled, they don't get settled with, oh, well, we're going to do a license in the U.S., we're going to do a license in Brazil, we're going to do a license in Germany. No, this is a global situation. One deal is done, all the patents on the table, you want them or you don't want them. So if you can get a huge lever as a patent owner in a big country or a big block like the UPC is, that is going to drive deals, I think. Would you guys agree with that?
That's definitely something which is discussed heavily in the user community, that the UPC is driving settlements. And if you look at the UPC statistics, we see a lot of early settlements where the cases don't go to trial. And let me just also comment on the broader question that you raised. So between the UPC and the UK, of course, they closely study the decisions of the other court, yeah, and the UK was one of the founding fathers of the UPC, yeah, that was prior to Brexit. Of course, they had the rules of procedure are also heavily influenced by UK judges, and the UPC judges pay great respect to the UK judges. When it comes to the world of SEPs, it's a bit different because each court may want to decide the case that was brought to it first. And then there is a certain rivalry, which you have seen now maybe with these interim licenses and also the anti-interim licenses, injunctions now issued by the UPC to stop the UK courts. There's currently maybe a little bit of a discussion ongoing, but that relates only to the world of SEPs. And apart from that, I want just to mention we have this development that the Court of Justice of the European Union said, if you sue a UPC land defendant that is also selling to the UK at his corporate seat, so where he is domiciled, the UPC has also jurisdiction to issue an injunction for the UK. So de facto, we have a new ruling which expands the territorial scope of the UPC to all countries which belong to the European Patent Convention, and that includes the UK.
So that's interesting. So even though the UK is not actually a part of the UPC, an injunction would apply to the UK because of a different treaty.
Well, the concept is if you have a company based in UPC land, you can sue them at their seat where they're registered for patent infringement wherever it occurs. That could be Spain, which is not a UPC country. That could be UK, could potentially even be the US. But the view of the European Court of Justice, which is in this case the last and highest instance all over Europe, is at the seat of the company, you can sue them for whatever patent infringement they do anywhere else. Of course, if they are not active in the UK, then there's nothing to be said about the UK. But if they are, then they are liable at their home court.
I don't know a lot of folks in America are going to feel comfortable with that, but I think patent owners will like that. That would differ. If I'm hearing this right, and I'm gonna need to look into this and read up some more. That would seem to be quite different than the way the U.S. courts handle that, and again, much more patent owner friendly.
Truth to be told, these are in practice not the normal cases, because typically what we see in every industry is somehow a distributed network of sales, right? Mm-hmm. So you have a subsidiary that sells in US, you have a subsidiary that sells in Germany. So you don't have these overarching worldwide actively companies. But, looking back 5 years at the Avanci litigation against German automakers, they, under this case law that now came out, they could have gotten an injunction for the US at the Munich District Court.
That's an important limitation. So the UPC is limited to the territory of the European patent. But before the national German courts, there is no limitation. You can bring a US patent before the German district court in Munich if the defendant has its seat in Munich.
So that strikes me as a much more next generation view of the world that takes into account that companies are multinational conglomerates, and accountants and lawyers, corporate lawyers, can try and set these things up, and not necessarily in a shell game, but sometimes it feels that way, where you have this company over there, then they're kind of isolated or insulated, and they're owned by the same parent, but we really don't know them. They're, we're a different entity and all that. Those games don't seem to be able to be played based on what I'm hearing you talk about right now.
At least much more difficult.
Interesting. So we have a question here specifically about budget, because I think a lot of people are going to want to know this as well. At least the patent owners are going to want to know it, because this is it should be an eye opener. If you haven't been paying attention to the UPC as a patent owner, you absolutely need to. How much should a patent owner expect to budget to bring a case at the UPC from start to finish? And while you guys think about that, maybe Tobias, I can ask you specifically. Your firm handles 20+% of UPC cases, right?
At least when the last UPC statistics were published by the court. They have now a new case management system, and for 3 months they stopped publishing the figures, but at the last time we saw it, it was still roughly 20%.
Okay, so you guys have a lot of, and I suppose you probably have a lot of experience across technologies, not just SEPs, but SEPs will probably be a growing portion of it now. And so with this question about budget, what should patent owners budget? If you want to break it up into, because I think there's probably different, for SEPs, it's probably one price. You got to be thinking about maybe for pharmaceuticals, a different level of case and a different price, or maybe not. I mean, what say you guys about the budget?
You're right. It depends, of course, on how complex the case is. I think if you look at a mechanical case, no FRAND involved, mechanical patent, you can get first instance, that's both infringement and validity, for 250, 300K. Yeah. If it involves FRAND, that of course goes up, pharma goes up. If it's technically very complicated, or you need experts, which is very rare here. But I think case would have to be very exceptional to go beyond $1 million, above $1 million. So I would say the average case would probably be 400, 500K, something like this.
I think the budget, of course, Tilman is talking about the attorney's fees of the patentee, the patent holder. He needs to budget also court fees. They are cheap. Less than 100K for the average case at the UPC. And then, of course, also the cost risks if things go south. And it's fair to say the same amount typically than for the own attorneys for the cost risk, more or less. So all in all, that still means a case, $1 million, budget, $1 million to $1.5 million. But it depends on the complexity, how difficult FRAND discussions.
I think that gives people some idea, and it seems like it's an order of magnitude smaller than the cost that you would have to be willing to front in the US.
Definitely, yes. And also still the UPC is cheaper than the UK. That's clear. What do you think, Arie?
Yes, also. Certainly, like I said, the UK are particularly interesting for FRAND cases. But then they also are expensive in the UK. So also with the UK, you talk about an order of magnitude more expensive.
What do you think that this means at large? And we've sort of been talking about this and kicking around, but I want to give you an opportunity to specifically comment on it. What do you think this means at large for patent owners who are going to the UPC? And I guess what I'm asking here is this going to have influence, do you think, beyond just the SEP space? Is this really a good sign for all patent owners like I think it is? Am I overblowing that? Is this SEP specific? What do you think?
Well, Gene, very simple. Of all of the cases, infringement cases before the UPC, only a very small fraction are FRAND cases. So that answers your question already. it is universally, not FRAND patents particularly, but for all patents, a very interesting venue.
I think at least this is my perception, I haven't reviewed the statistics, but what I see each week on Docket Navigator coming out and also the new cases filed, I see a huge share of now innovative SMEs that bring their cases to the UPC. That was not so in year one in my mind, but that has changed in year two. So which lends a lot of credibility to the UPC that it's now also attractive for the users for which it was actually set up, because that was the political mission to make patent enforcement in Europe more accessible for SMEs. Yeah, that was the whole idea of the UPC.
Well, certainly if the
no longer fragmented national litigation, but having one venue where you can get protection throughout Europe.
Yeah, and if the fees are as low as you guys, attorneys' fees are as low as you guys are saying, it really is approachable from for SMEs, and you get a resolution across multiple jurisdictions. And I think this will be eye-opening for a lot of people. And I would think that if the UPC is willing to give a final, permanent, non-appealable, now because the case is over, permanent injunction in a SEP case where there are FRAND issues, where there are no FRAND issues, then it would seem to be an even stronger, easier case for the patent owner to make, because in the FRAND world, you are making some obligations as a patent owner to engage the other side. You know, you lay out your technology, that you want them to use it, you're encouraging them to use it, they use it, but of course they have to pay for it. But that whole enticement back and forth, setting of standards, that kind of does change things a little bit. So if the courts are willing to do it for SEPs, I think they're going to have to be willing to do it for everybody.
Yeah, that's true. I don't think they differentiate at this point. And of course, FRAND is always a level of complexity in any litigation if it comes up. For this specific case here, it's probably important to note it's an SEP case. So the patent that we litigated is standard essential for the Qi wireless charging standard. But the defendant didn't raise a FRAND defense. The reason being, they did it in the preceding German national case, and the FRAND defense was dismissed in that case. And our belief was we expected them to raise it again, but they did not in this specific case. So they didn't make a FRAND defense despite this being an SEP. Therefore, also the court didn't look into this.
So would they have been able to raise that again in the UPC case? I mean, I understand you guys could raise different issues at the UPC, maybe different patents, different claims, but the FRAND issue is not claim by claim or even patent by patent. It's like we're offering you a whole bunch of patents. So if they lost on that issue, that would seem to have flow through to the UPC, no?
In principle, both courts would apply the same standards, the same legal standards, but they were not technically barred from raising this FRAND defense. Yeah? That was a decision they made. They could have raised the FRAND defense again.
Okay.
Would it have been successful? I don't know. I doubt so, obviously. Otherwise, we wouldn't have sued for an injunction, but they just didn't. Why specifically, we do not know.
So we have another question here about trying to get, and this is really from a U.S. perspective, get our heads around this interplay between what happened in the previous German case and now what happened in the UPC. Is it fair to say that the UPC is now, that decision is binding on the German courts, or how does that work? Or, I mean, are they just different cases so that there really is, you know, they're totally different lanes? Or it feels like to me, like, and I'm speaking as an American, and so I'm hoping you guys can explain this to me. It feels a little bit like the UPC is above the German national courts. I don't think that's the case, but I think that will be the perception that a lot of Americans may have.
I can just comment from experience that I had other cases where we had an interplay of national German litigation and UPC litigation. And what I just gathered from the hearings before the German courts, they looked very closely what the UPC was doing, but there is no, legally speaking, a binding effect. Yeah, they can decide differently. It's a different substantive law. The German courts are not applying substantive UPC law. They are applying German national law. And conversely, I also think the UPC closely studies what the German courts are doing, but they don't feel bound. And there comes the thing. It's an international panel. There are not only German judges at the UPC. Yeah? You have judges from all UPC territories. And of course, they look at the German decision and say, interesting, but I'm not convinced. So maybe you have kind of a better chance that the UPC deviates from the German decision rather than that Germany would deviate from the UPC decision. That's my personal perception. Future may prove me wrong, but that I think will happen. What do you think?
Yeah, Tobias, I by and large would agree with that. I think the whole idea, so the landscape we've had in Europe until the Unified Patent Court came to existence, and we took a long time actually getting it up and running. I think it started as early as 1975. There were discussions on this, so it only took 50 years. But that was inspired by the fact that we had this European patent, which falls apart in a bundle of national patents, which are then litigated before national courts, basically using more or less the same legal standards and provisions, and we saw different decisions coming out. So this fragmented litigation space was the very reason why this Unified Patent Court was put into place. So I think the judges, which is an international community of judges, ought to set them the holy task, and actually they take it very seriously, to put up their own autonomous law as to how this should be, of course, respecting all the national laws or the EU law that's already out there. So they are setting new law here, and therefore it's a different jurisdiction than the German jurisdiction. It's a different jurisdiction.
We have one aspect in this case, and that was the question: are the directors of a company liable for patent infringement of the company? That's, for example, the German approach. In Germany, basically, they are kind of automatically personally liable if the company was found liable for patent infringement. And the Court of Appeal expressly deviated from the German approach because they said that's an autonomous UPC concept. Who is an infringer?
Yeah. We lost on this part of the case. I'm not unhappy that we lost on that part of the case, actually. Because I think as a general for my company, we are very reluctant to actually involve personal people in our litigations. I think they should be conducted with the companies that we deal with. We had a very set of exceptional circumstances which we felt we had to do this, but it's not something that we would normally do. And the standard which the UPC court now has set in terms of a director becoming liable is quite high. It's not impossible, but it's a very high standard to overcome. So I don't think we will see it as a very common strategy to actually sue the directors of a company.
This may be different if we have a first instance ruling and the defendant is violating the order, the court order. Then situation changes.
So there are factual situations where that could happen, but not easy to pull off.
It requires a pretty bad actor in order to get there.
That's what I was just going to say. So there's some malevolence involved, and if there is, then there's recourse, but short of that, ordinary case, not going to happen.
Yeah, no,
correct.
That's correct.
Fair summary. Yeah.
Okay. So we're down into the final few minutes here, and I'd like to give each of you guys the opportunity to wrap up however you want to wrap up. I know we've really just scratched the surface on this case, and I suspect that you all would be willing, if people have questions, to reach out to you and ask you, some very specific questions if they have them. Because we could talk about SEPs, FRAND, in this particular case, injunctions, literally all day. But open mic situation for you guys as we leave. What do you want the audience to take away from today, from this case, from what our conversation has been? What's your takeaway message? And I'll give Tilman the last word since this was his case, quote unquote. But Tobias, let's start with you.
Generally speaking, the users can trust the UPC. I haven't read on social media criticism of a single decision as having been a crazy decision. Yeah, you may not always agree, but I think everyone respects the quality of the UPC's decision. Today, just a third panel of the Court of Appeal was announced. High caliber judges were appointed again. So I think the momentum of the UPC will keep going.
Excellent. Thanks, Tobias. Arie.
Yeah, I would generally agree with Tobias said. I think our company, we were very much in favor of there being something like a unified patent court. We've been working on that for a very long time. So we were excited that it finally came to be. It looks like a very exciting proposition when it opened its door now slightly over 2 years ago. And I think having now looking back at the time that we've seen, I'm still excited. I think it's been delivering generally what it promised it would deliver, and it's a very attractive offering, I think. But not only on a patentee side, not only on the plaintiff side, but I would also say on a defendant side, you get a fair deal. For example, we didn't talk about one nation, but it's a general rule that if the loser has to pay the other party its own costs as well. Yeah.
Right.
So you're not only holding the short end of the stick as a defendant. You know, if you win your case, you get your costs back. I think it's a very reasonable offering in that sense, and it's starting to becoming too successful. We've seen in some cases that the timelines are starting to slip because there's so many cases brought. So it's already becoming a little bit too successful, you could say, in that respect. So those are my words.
Excellent. Good. And we should come back to that and have that conversation about from the defendant's perspective, because I know I'm excited. I know you are excited since this was your case, but about the possibilities from the patent owner's side. But I do think it's important that we tell patent owners, the eyes wide open. The defendant is going to have their opportunities. This is not a one-sided tribunal by any imagination. And there does need to be a certain self-selecting nature involved here. You just can't throw up against the wall any claim, because eventually you're going to wind up paying the other side. So excellent points, Arie. Thank you for being here. Really appreciate it. And Tilman, the final word goes to you.
Yeah, so I can vastly echo what has been said. I think really also if you dig into this decision, it's very balanced. Yeah, a lot of aspects looked at thoroughly. And for example, on the liability of directors, the UPC came down at the other end of the spectrum where, for example, the very strict German approach is. But in general, for us, I think it's been a great time. We've been involved from the beginning, as you mentioned, Gene, and we have seen a lot of teething issues gone away. A lot of new stuff and weird stuff that happened in the beginning, and what we had to deal with is now ironed out. It's gaining up more momentum. And yeah, you have a very accessible, high quality court system that can cover a market that is the size of the US. If you count the population of the 18 current states, that's roughly the same consumer base you would have in the US. So I think, yeah, as you put it today earlier, that can be quite a leverage in any IP situation you're facing.
Excellent. Well, thanks, guys. And let me just tell the audience, look, there's no legal advice here. This is just for information purposes. Your cases will all differ, and you really should, before you decide to rush head in, talk to somebody who knows the ins and outs and can really give you good advice on what the likelihood of success is going to be and form a strategy. The conversation today is intended to open your eyes into the possibility of this being a strategy that patent owners should at least investigate, I think at a minimum. And then with proper counsel, I think a lot of you are going to want to pull the trigger. But if you have any specific questions on what to do moving forward or have any additional questions you'd like addressed, you can reach out to us. You can reach out to Tobias or Tilman. And guys, congratulations, Arie, as the patent owner here. Congratulations to you and congratulations to your team at Bardella Pagenberg. I really appreciate you spending the time talking to us today.
You're
Thank
welcome.
you.
Thank
Thanks
you,
for the
Gene.
opportunity.